My Lord, I've got my two little bits of homework.
Yes, please.
Very quickly. First of all, was the question from my Lord Justice Arnold about whether we were saying that Mr. Bradford accepted that the technical considerations, or whether he accepted that the technical considerations underlying the Panasonic document, and we say he did accept that there was no known index of control channels, which is one of the technical considerations that is pointed out in the Panasonic document. I've already taken my Lords to that piece of cross-examination, but I'll just give you the reference again for your notes. Supplemental bundle tab 28, page 324, and it's page 264 of the transcript, lines 7 to 10. Then, in relation to the question of whether we ran this particular obviousness case in relation to the 810 patent at first instance, the position is, as far as we can tell, that we didn't run it explicitly, but it was obviously implicit from the case that we were running on construction of the 810 patent, because there was no point in running the case about the wide construction unless we were doing it for the purpose of obviousness, because there would be no reason to bother to make the argument that the index of the control channel fell within it if all we were fighting about was whether CCEs were obvious. And so we say it was implicit from that, and that as far as the evidence is concerned, the evidence references that Optis are relying on at paragraph 57 of their skeleton argument on appeal, which I've already taken my Lords to, are consistent with the fact that this is obvious. And in addition to that, we say that there is a very short bit of evidence of Mr. Bradford in his first expert report at paragraph 418, which is in supplemental bundle tab 6, page 122, which we say is also consistent with the position that this would be obvious, and that was why we didn't need to cross-examine on it. And I don't know whether my Lords want to turn that up now, but as I say, supplemental bundle tab 6, page 122. It's very brief, and all it says about 2/3 of the way down the paragraph is that the skilled person may have assumed that as the standards develop, a logical ordering of the PDCCHs would be developed. And so that's all entirely of a piece with the fact that the evidence of both experts was that there would be, that this was technically possible and the indexing would be developed, and therefore we say that that is sufficient for obviousness. I was now proposing to sit down unless there are further questions.
Ms. Hitchett.
So, my Lords, we were going to turn to the patents and then work our way on to the construction and infringement points. So could I ask that your Lordships have primarily the judgment out, so that's or tab 5 or wherever my Lords have it. And if we start off at paragraph 206, but it may also be helpful to have supplemental bundle to hand because the patent is in tab 1 of that. And like my learned friends and the judge, I'm going to deal with it primarily from the 549 patents. So if we look at the judge's high-level summary in starting at paragraph 206 of the judgment, where he sets out, in essence, what the inventive concepts of the claim are. And in 207, he says the mobile has to be able to spread and transmit the ACNAC and the CQIs, although it will not do both at once. And the reason why I pause on that is I'll come back to that when we look at the point of construction and the user's point, because of course the claim says that the UE has to use a particular Kazakh sequence to spread CQIs and use a particular Kazakh sequence to spread the ACNACs. And if my learned friend's construction is right, users means actually doing it, which implies doing it at the same time, although as the judge found, the UE wouldn't be doing it at the same time. As the judge explains the mobile will spread and transmit with its ACNACs in accordance with a code multiplexing structure. Now, the term code multiplexing structure was in issue at trial, as it is on appeal. And what I want to do now is just go forward to where the judge deals with this, which is paragraph 241 onwards. Because when addressing your lordships yesterday, my learned friend says, well, the code multiplexing structure is an abstract structure known to the base station. And that's part of the judge's construction and definition of the words code multiplexing structure, but it's only part of it. And the bits that she didn't touch on are also important. So we see in 242, he accepts Apple's submission that the code multiplexing structure is an abstract logical structure known to the base station, and it sets up a logical pattern of cyclic shifts and orthogonal sequence numbers by which the network dictates exactly where mobiles can multiplex their ACNACs and their CQIs. And he refers in the next paragraph, one could perhaps think of the code multiplexing structure as a map or a set of rules. So it's the rules about where the UEs can, and also importantly can't, put their signals. And so far the construction that the judge has got to isn't challenged by either party. And as the judge says in 243, and as we can see, if my lords flick back, or look in the patents actually, that'll be easier where we have both open, to figure 10. So that's supplemental bundle, tab 1, and figure 10, which is on, at least on internal page 25 of the patents. And my lords are hopefully getting familiar with this. And the reason this morning for labouring slightly the point about the combinations of codes is when one first comes to this case, you could perhaps look at this grid rather like the resource block of LTE, but that's not what it is. It's a table showing code combinations. One has the 12 cyclic shifts of the Zadov-Chu sequence going in the rows, and then the Walsh codes in the columns. And what one can see is that the code multiplexing structure is made up of the combinations where in the table there are CCE numbers. My lords now will appreciate why those CCE numbers are there, because they're the downlink CCEs that tell the UE which combination of codes to use. So the code multiplexing structure, the UEs are allowed to transmit on the ones that have CCE numbers in them, and they're not allowed to transmit in ones that are either blank, or in the case of cyclic shifts 3 and 4, they're only allowed to transmit CQIs in cyclic shift 3, and they're not allowed to transmit in cyclic shift 4 at all, because they've been crossed out and held to be unusable. And another illustration is the one the judge uses at, another one the judge has in the judgment at page 214, but we needn't turn that one up. Now, if we go back to 244 of the judgment, the judge recalls that there was an argument at trial about whether the code multiplexing structure must also be present in the mobile, and that had been Optis's submission, and the judge rejected that submission in its widest, but he goes on to say, importantly, that the mobile must of course be adapted to spread and transmit in accordance with the code multiplexing structure, and a mobile which was programmed to put ACNACs and CQIs in places the code multiplexing structure did not permit would not be so adapted and will be outside the claim. It also wouldn't work. But all that doesn't mean it has to have the entire code multiplexing structure. It may have a simple procedural code that ensured compliance without having the whole map. Now again, we don't discern that paragraph is challenged on appeal. But we do say it's important, because what it's making clear is that to be adapted to operate in accordance with the code multiplexing structure, the UE has to have some procedural code in it to make sure that it only puts the ACs and NACs in the places allowed by the code multiplexing structure, and it also has coding that prevents it from putting it in the wrong places. And we'll see that that is of significance when we come to look at Nokia. And then next paragraph 245, the judge refers to two for the nuance. Now, my learned friend didn't address you on these in her address yesterday or today. Well, I just want to make sure your lordships have these paragraphs because you may not have focused on them. The first point is the judge concludes that there's nothing in the claim to say the mobile has to use the same code multiplexing structure all the time, or that it can only be adapted to work with one of them. And we say that's plainly right when one looks at the words of the claim, and we'll see that in a moment. And the second point over the page was that the judge rejected a submission that the code multiplexing structure is only that part of the 12 by 3 grid actually in use at a given moment. And as the judge says, if the network only scheduled 6 mobiles, the argument that was put with the code multiplexing structure would only include those that were being used. And we say that's a plainly correct conclusion, and I didn't detect a challenge to that. So if one goes back in the judgment 2 pages and sees the judge's reproduction of figure 7 of the patent, just by way of an example, the code multiplexing structure is all of those resources that have got the CCE numbers written in them, other than the, and those are the ones that are available for use. And those resources remain part of the code multiplexing structure, even if in one particular subframe there's only 6 UEs that need to send their ACNACs back. And as the judge explained, you can see that from the fact that the diagram is headed 4 ACNAC use and 4 CQI use. There are resources that are available for that use, and they don't cease to be part of the code multiplexing structure just because at any one instance they're not in fact being used. As I say, although there was some challenge to that in my learned friend Skeleton, I didn't detect that she was maintaining that before your lordships. So, having looked at what the judge concluded as regards what a code multiplexing structure is, if my lords can turn back to where we were, which is paragraph 208, and where the judge explains what the particular code multiplexing structure of the claim is. And as he says in 212, claim 1 calls for a checkerboard or mesh pattern of the general kind shown in figure 10, which has what the claim calls a 2 cyclic shift interval. That refers to the fact that, for example, the square denoted CCE1 within wash sequence 0 is 2 cyclic shifts from the next one. And we see that in the diagram. And further feature of the claimed code multiplexing structure, as my lords will have now, is the unusable cyclic shift that follows a cyclic shift used for CQI use. And you see in the diagram there, cyclic shift 4 is marked unusable because it follows cyclic shift 3 for CQI use. And both those arrangements of the available resources, the 2 cyclic shift mesh for the ACNACs and the unusable cyclic shift after the CQI, are both there to deal with the delay spread issue because they reduce the chance of interference occurring if delay spread occurs on a signal, and it reduces the prospect of 2 signals being confused with each other. But of course, the overall system achieves the other aim of the overall arrangement of the code multiplexing structure, achieves the patent's overall aim of allowing efficient multiplexing whilst at the same time avoiding the delay spread issue. And the patent makes those points in paragraphs 12, 13 and 15. Now that's the code multiplexing structure, which is the invention of 549, as my Lord will now appreciate, the 810 patent adds on a further feature, which is the implicit signalling. And again, we're looking at figure 10 of the patent, either in 208 of the judgment or in the patent itself. My Lords will understand now how that works, is that the CCE used in the downlink has been mapped onto a particular resource, and the UE knows implicitly from where its allocation message was sent to it what resource to use in the uplink. And of course, the advantage of that method is it cuts down on downlink bandwidth and signaling. So that's the high-level summary, the inventive concept of the patents. If we can go into the second tab of the core bundle and just look at the claim itself, just to see where those features appear in the claim. To deal with some of the points as they arise. So integer 1A is the mobile station adapted to spread and transmit the ACNAC or CQI in accordance with the code multiplexing structure for code multiplexing ACNACs and CQIs from a plurality of mobile stations. And the words from a plurality of mobile stations making it clear that the multiplexing is the ACs and NACs and CQIs are coming from different mobiles, not all from the same one. Integers 1b to 1d are the three spreading units that spread the ACNAC with one cyclic shift of a sequence, the CQI with a cyclic shift of a sequence, and then the third spreading unit that additionally spreads the ACNAC with one of three orthogonal sequences. Now, just pausing there, the claim is limited to there being three orthogonal sequences, three Walsh sequences. And that was a major issue at trial. And your Lordships haven't been troubled with any of this because the obviousness case isn't being raked over. But one of the key reasons why the judge found that or dismissed the obviousness case over both the Panasonic prior art and the Nokia prior art was that he held it wasn't obvious to use three orthogonal sequences. Rather, it would have been obvious to use all four that were theoretically available. And the reason why I stress that now is at times, yesterday, when my learned friend was dealing with the Nokia prior art, you might also remember the issue of the unused Walsh sequence. And I think she said at times, well, if you were using all four, you're still using the invention because you're using 3 plus 1 more. Now, that we don't accept. It wasn't argued below that using 4 orthogonal sequences hit the feature of the claim that required there to be 3. It certainly wasn't the way the trial progressed, and we can just to give away an example, just to show my lords how the judge dealt with this. So in the judgment, go on to paragraph 396. So this is having dealt with the disclosure of Nokia. The judge says there are 2 steps to consider, although maybe they could be split. The first one, using 3 codes for data with the 2 cyclic shift gap. And then he goes on in 397, Nokia doesn't disclose 3 codes, and he deals with the merits of the arguments and finishes up in 404 to say Nokia doesn't make it obvious to have a code multiplexing structure with 3 blockwise codes for data. And the rival arguments were, well, the reason why is because the skilled person would want to use all 4 Walsh codes to spread out the resources across the available code space. So we do say that point, which may be one that just arose on the hoof yesterday, is not a good one. The words of the claim, when one looks at them, require there to be one of 3 orthogonal sequences, and that feature simply isn't met by a system in which the UE can spread over 4 orthogonal sequences. So those are the spreading unit integers of the claim. Then the control section, which is adapted to control the spreading, and I think we agree with my learned friend when she says that those three integers don't really add much more over the previous ones. Then 1H, we have the transmitting unit, which transmits the ACNAC signal and is adapted to transmit the CQI signal. And then over the page, we come to the characterizing portion of the claim. And I'm going to come back to this concept in a moment. But there's a question that my Lord Justice Birss asked yesterday, and it may be that the interest in the question is waned, but I will deal with it. My Lord picked up on in 1K, where it says the cyclic shift value between the first cyclic shift values and the second cyclic shift values is not used for either ACNAC or the CQI signal. And I think my Lord was suggesting that that was where the two cyclic shift mesh comes in. But well, that isn't the case. What's going on in integers 1i, 1j, and 1k is in integer 1i, it says the first spreading unit in each symbol that forms the ACNAC symbol uses a co-multiplexing cyclic shift value of first cyclic shift values, and the first cyclic shift values from a portion of the 12. So what that's saying, that there's a portion of the available 12 cyclic shifts that are used for ACNACs. The next integer, but when the second spreading unit is spreading the CQI, the second cyclic shift values, which are the ones for the CQI, are not within the portion of the 12 that are used for ACNACs. And then finally, the cyclic shift value between the first and second ones, which are the ACNAC ones and the CQI ones, is not used by either. So what these integers of the claim are doing is defining the arrangement of the available shift to say that there's a portion that's used for ACNACs, there's a portion that's used for CQIs, and in between there's one that's not used for either. So that's what this is doing. Then integer 1L is where the two cyclic shift mesh is defined. 1M makes it clear that the CQI signals aren't spread with the Walsh code with an orthogonal sequence. And 1N comes back and refers to the position of the unused shift comes immediately after and immediately preceding CQI, so after a CQI and before an ACNAC. So the combination of all those integers, and we accept it's a long claim, get you to the judge's summary of the claim, which we looked at and which is accepted to be accurate. Now, the dispute on construction is whether properly construed, the claims require that the cold multiplexing structure is actually in use for the device to fall within the scope of the claim. That's the starting point for the argument. And there are two aspects to this, to the judge's decision on this. The first one, as we've seen, is what the cold multiplexing structure is. And the second one is what's required for a UE to be adapted to spread and transmit in accordance with that structure. And we've seen how the judge has dealt with that in paragraphs 242 onwards of the judgment. And my lord's now aware of the conclusions he came to. But it's important that the adaptive feature, as the judge held, requires that the UE is able to put the required signals in the right place, and not able to put them in the wrong place. Now, the context behind Apple's argument is the issue of the implementation of the mixed resource block feature in the UK. And this is one of these issues that comes up from time to time with technical standards, is it's quite common for there to be features in the standard that are optional for a base station to put into effect. So the base station manufacturers get the choice whether to implement it or not, but are mandatory for the phones to be able to deal with. And the reason why that's the case makes sense when one thinks about it, because if a UE happens to blunder into a cell where the base station manufacturer has chosen to implement the optional feature, you need your phone to be able to deal with it. And this is one of those features. And so Apple's phones, Apple's devices, and all other LTE compliant mobile phones have the necessary code in them that if a base station tells them it's using a mixed resource block, they can spread and transmit their ACNACs and their CQIs in accordance with that code multiplexing structure. And that's not in dispute. The judge records it at paragraph 287 of the judgments. Where he says, top of the page, the phones have the necessary logic, albeit that it's never put into effect in the UK for the code multiplexing structure on which Optis relies. Now, because of that, the process claims, the method claims in the patents weren't pursued to trial, but the product claims were, as my lords will be aware. And it's important that Apple's phones are able to comply with mixed resource blocks if and when they were to arise. And that's for the reasons that the judge gives in paragraph 274 of the judgments. Firstly, if the phones were to roam, so the phones were to go to a country where the network operators did use mixed resource blocks. And secondly, because, as Mr. Bradford explained in his evidence, compliance with mixed resource blocks is an important part of passing the LTE conformance tests, and the phones need to be able to pass the test so they can be sold as LTE compliant phones. So it's an important part of the phone, important for a phone to be able to comply with this functionality. As one might say, you can see by the fact that Apple haven't taken the functionality out of the phones. So I want to now turn to the 4 reasons that are relied upon as to why the judge's construction of the claim and his construction that doesn't require code multiplexing structure to be actually in use for the phone to infringe, why Apple says that's wrong. And the first one is the use of the word users in places in the claim, in particular in the characterising portion of the claim. And what we did, I don't know whether my lords might find this helpful, in our skeleton, so that's core bundle tab 4 or somewhere else, if my lord have taken it out, on page 4 of our skeleton at the bottom in paragraph 11, we put some of the integers of the claim and we've colour-coded it to highlight the relevant wording. So we see in integer 1a, the adapted to wording has been highlighted in yellow. Now, it's not, I understood my learned friend yesterday, it's not in dispute that adapted to in this claim has its usual meaning, that the phone has been programmed or is suitable or capable to do the features that it's said to be adapted to. Her point, as we understand it, is that later on, because of the present tense users in the claim, that effectively requires us to strike out all the adapted to wording.
No, she says there's a distinction. She says, look at the pre-characterising portion, it says adapted to 4 times, but when you come to characterising, the language, the characterising portion of the claim, she says, the language shifts. And whereas adapted to was being used, it's now no longer used, and instead the language is uses stroke not use. So she positively relies upon the contrast.
Yes, but that requires the phone to be one that is, rather than, as the claim starts off, being just suitable to do the various steps, is one that is actually doing it and effectively rewrites this claim as though it's a process claim.
unimportant point. Have you left out the uses in 1J?
I think we've taken
deliberately omitted
some of the integers. I think rather than the footnote says the same point arises in relation to the CQI signals. I think we've deleted the CQI signals.
Oh, I see. Yes, you're quite right. It does explain that.
But the point we make on the colour coding is we see that in 1E the control section is adapted to spread the ACNAC signal by the first spreading unit by setting a code multiplexing cyclic shift value. So it has to be capable of doing that. And then when we get into integer 1I, which again is the characterizing portion, as the first spreading unit has to be uses that. And we say that the green language that links back links it all through, and that the judge was entirely right when he said that read in context, the word users in the various places where it appears in the characterizing portion is to be understood as meaning what the UE will do when it's actually doing steps that it's capable of, it's been adapted and programmed to do. Now, yesterday, my Lord Justice Birss pointed out that the claim doesn't just require the UE to use certain things. So when we look at integer 1I, the first spreading unit has to use the said multiplexing cyclic shift value. And obviously, my learned friend relies upon the present tense as to saying that has to actually do it. We go over the page in our skeleton, 1K, there has to be a cyclic shift value that is not used. And if we're looking at the tense of the language to imply actual doing of something, it's quite hard to reconcile that when you've got in the same tense something that's telling you not to do something. And there's a tension there in the language, and it doesn't fit with my learned friend's construction of the claim. There's a further point on this, which is the point I mentioned. We started on the patent at 2 o'clock, which is that the claim obviously refers to spreading and transmitting both ACNACs and CQIs, whereas the judge explained a UE won't be doing both at the same time. So my learned friend's construction also falls down, because she reads use as meaning actually doing it, but no UE is actually going to be transmitting an ACNAC and a CQI at the same time.
I'm not sure I understand that. Why do you say that's required by Apple's construction?
Well, because my lords, the words users come in both in relation to the first spreading unit that uses the code multiplexing structure value of the first cyclic shift values, and then the second spreading unit uses code multiplexing cyclic shift values of the second cyclic shift value. So if users means actually doing it, then the consequence of that construction is it has to be using both at the same time. If it doesn't mean that, one falls back to what it means is this is what it uses when it does it, which is of course the judge's construction. But the UE will either be sending an ACNAC or a CQI. And if I can just give my lords just a few references to this specification just to make that point good. So can we go to Supplemental Bundle tab 1 and paragraph 50. And perhaps my lords can just read 50 to yourself, and then I'll just explain. it's the point of it's the paragraph, the section at the end at line 50, that the control section controls transmission such that if directed to transmit a CQI in advance, it selects the CQI, and if not directed, it selects the ACNAC. So it sends one or the other. And if we then go over to 53, over the page, it says transmission signal section 222 selects either an ACNAC signal received as an input from CP adding section 217 or a CQI signal received as an input from CP adding section according to the setting of control section, and outputs the selected signal to the radio transmission section as a transmission signal. So those two paragraphs, as well as the opening language of the claim that makes it clear that it's for a plurality of mobiles, make it clear that a UE either transmits one or the other. And given the use of users in the claim in relation to both ACNACs and CQIs, that my learned friend's construction is inconsistent with the disclosure of the specification and the skilled person's understanding that it will be one or the other.
But what's used is the CMS, which is the logical path.
Well, my lord, the claim, the language she relies upon, is used as the code multiplexing cyclic shift value. So, and that's integer 1i. Of course, that's what happens. When the phone does in fact send, in this case an ACNAC, it will use the relevant cyclic shift value to code multiplex its signal. And when it sends a CQI, it will use the relevant cyclic shift value to code multiplex the CQI signal. But we say that the judge was entirely right, that what in context what users means is when it does it, this is how it does it, rather than meaning that that it has to actually be happening for the phone to fall within the scope of the claim.
Is this a point that the judge relied on in his reasoning?
Well, the judge's reasoning was that users in context meant this is what it does when it does the thing.
To be sure, yes.
But the point about only sending one or the other, no, my lord. Now,
so to be clear, you are presently advancing a submission which you say supports the judge's construction, but it's not a reason that the judge himself relied upon.
No.
Yeah. Thank you.
Now, I don't know if I made some.
I think you got it from me. Well, I'm not sure I thought it through to that extent.
So now I will move on to a related but slightly different topic, which is the characterising portion point. And my learned friend places weight on the fact that the adapted to wording is in the pre-characterising portion, and the user's language is in the characterising portion. And she says this emphasises the novelty in the claim must lie in the actual use, because the pre-characterising portion is conventionally meant to be prior art. But what I want to do is just hand up just some extracts from the EPO guidelines, if I may, because just to give one of the highlights of where I'm going, the division of a claim between that's my one. We'll do that one. Characterising portions and pre-characterising portions is not mandatory. It's optional.
But also, I'm sure I've said in the judgment that where a claim has been amended post-grant, the presumption as to the pre-characterising portion being based on the prior art is less strong anyway.
Well, indeed. But so what I was going to show the court is in this little extract from the guidelines on the first page of the text, we see 2.2 two-part form, and let me just pick up the one that I haven't actually marked up, which is not helpful. So we see the Rule 43 defines a two-part form, the claim which a claim must have wherever appropriate, and that's the key wording. And the EPO do have a preference for the two-part claim. And the first part is meant to be a recital of the prior art features, and then over the page we see the second part, or the characterising portion, needs to state the features which the invention adds to the prior art, i.e. the technical features for which in combination protection is sought. But they say then in the second last paragraph in this section, where however a claim relates to a novel combination and where the division of features of the claim between the preamble and the characterising portion could be made in more than one way without inaccuracy, applicants must not be pressed unless there are very substantial reasons to adopt a different version of the features from that which they have chosen, if their version is not incorrect. If the applicant insists on including more features in the preamble than can be derived from the closest prior art, this is accepted. And if no other prior art is available, and so on and so forth. And then there's a section on two-part form, unsuitable. Subject to what is stated in 2.3.2, applicants are required to follow the above two-part formulation of their independent claims, where, for example, it's clear that the invention resides in a distinct improvement. However, as indicated by Rule 43, this form needs to be only used in appropriate cases. The nature of the invention may be such that the form of claim is unsuitable, e.g. because it would give a distorted or misleading picture of the invention or the prior art. And they give some examples. And so the point is a simple one, is because the two-part claim is only to be used where appropriate, it can't be an ironclad guide to construction to say anything in the pre-characterising portion must be old, and therefore you can assume that the novelty comes from the user's word in the characterising portion rather than the adapted two-part in the pre-characterising portion.
But you don't say that the two-part form was inappropriate here.
Well, it is in the two-part form, my Lord.
Yes.
As my Lord Justice Arnold explained, it has been amended, and that throws some difficulty in.
Yeah, because the real point here, surely, is that you had a two-part form in the granted claim. You were therefore stuck with a two-part form. However, it's subsequently been amended, and obviously in making the amendments, you had to start with the structure of the granted claim.
Yes, I mean, so there's some grumbling from the judge, understandably, that this is a long claim, and to which the answer is, well, if we weren't starting from where we had to start from, we might have ended up with something shorter. But we had to do it that way. But to answer my Lord's point is the reason why I'm taking you to this is because for it to be a rule of construction to say, well, this must follow, the skilled person has to understand that the two-part claim will always be used, and you can't rely upon that. And so whether for this case it was appropriate or not isn't really the point. The point is you can't rely upon everything in the pre-characterising portion being in the prior art, because as the guidelines said, if an applicant insists on putting more stuff in the pre-characterising portion, that's fine.
I mean, I follow the point in a way, but will not the interpreter nevertheless attach significance to where stuff is to be found? And though this has been amended, the adapted and uses were in the original version, weren't
They were in the pre-characterising portion in the original claim, yes.
Yeah.
But ultimately, my lords have to construe the claim as a whole, and have to construe it looking at all the features, and can't make these kind of assumptions that my learned friends suggest. The other premise in this point is that it's the only part of the characterising portion of the claim that the skilled person would see as giving novelty to the claim is the user's word. And I think, as my Lord Justice Birss pointed out yesterday, of course, the two cyclic shift mesh feature is in the characterising portion. And skilled person, as we'll come on to in a moment, I'm dealing with other my learned friends' points, that's not conventional for skilled person, despite the mistaken attachment of the list of figures in the patents. And Nokia itself doesn't have it. She accepts it. So that's a feature that is novel and inventive, as the judge found. And equally, the unused cyclic, or the unusable cyclic shift after a CQI is also not in prior art, and as the judge found, not obvious over the two pieces of prior art that were relied upon. And so the argument, my friend's argument with respect, just doesn't get off the ground. It starts from the premise that it can only be the user's bit that distinguishes it, therefore you have to put this in, where there's a whole host of other features, at least two other features, that also give novelty and inventive step to the claim in the characterising portion. So there's nothing to drive you to saying that users must be construed as meaning when actually used, rather than as the judge has construed it, as meaning, well, the phone has been adapted so that when it does it, this is how it acts. So I think I've dealt with the points that my learned friend addressed you on yesterday and today. I think just for the sake of completeness, there were 2 points that she challenged in the judgment that she didn't address you on, but did in writing. I want to just give you our high-level answers to them. I don't want to take up too much time, given that they may not be being run, but equally I don't want to find them appearing in reply and me not having dealt with them. So this is going back to the judgments at paragraph 245. And there's the two nuances that the judge refers to there. And in her paragraph 44 of Apple's skeleton, this one is said not to be correct. I say, although she didn't address you yesterday. So this is that there's nothing in the claim to say that the mobile has to use the same code multiple structure all the time. And the judge rejected that. And if we look at I always have the claim to hand in Supplemental Bundle tab 2, the apparatus of the claim has to be adapted to spread and transmit in accordance with a code multiplexing structure, and that structure has a whole series of features. But there's no limiting language in the claim that says it can only do that. And equally, at the end of integer 1a, the point I should have made in the same breath, is that the radio communication apparatus is comprising the following features. And comprising is conventionally, as my laws know, construed as being non-limiting language. So there's nothing in the claim that excludes the phone being able to do multiple code multiplexing structures. And indeed, you can see embodiments 1, 2, and 3 are slightly different code multiplexing structures, and they're all, at least as the claim is amended, embodiments 1 and 2 fall within the claim. The second point over the page in 245, again just for the brief answer, this is that to the point where the code multiplexing structure is only the part of the grid that's actually used in a given moment. And the judge rejected that, and we say he was right to do so for the reasons that he gave. The code multiplexing structure are the resources that are available to be allocated to the UEs at any particular time, and that's a separate issue as to whether they are in fact used, which will just depend on how many UEs are receiving data in the downlink. And I think there's probably not much more I need to say about that, other than to flag that the reason why I'm taking your lordships to this point is it becomes very important when we get to Nokia, because the way that Apple try and arrive at the two-cyclic shift mesh from a phone that can use all the available resources is to postulate that only some of them are used at one time, and then they say, hey presto, it looks a bit like the claim. But there's a fundamental difference between the two, as we'll come on to, is that in the claim, the UEs can't put ACNACs outside of the two-cyclic shift mesh. There's a phone that's been adapted to spread in accordance with that structure can't do that. But in Nokia, the phones can, because they can use all the resources. So that's her first point on the wording of the claim. Apple's second point is on the description, and there are two aspects to that. The first one is the conventional point, and figure 7. And again, if we can pick this up from the judgment, it's paragraph 227. And the premise of this argument, as my lords will remember, is that in the list of the figures, the patent describes figures 6 and 7 as being conventional. And I think the precise words my Lord Justice Arnold said yesterday are conventional case 1 in both cases. So,
and when I pointed that out to Ms. Lane, she said that wasn't a point that you'd taken below.
It wasn't a point we took below, my Lord. No.
That it's the same language,
No.
which at first blush seems, shall we say, counterintuitive, given that they're different.
No.
Yet they're described in the same way.
The points we took below are that it's simply wrong. The skilled person who, with their common general knowledge, would look at that statement of conventional and would say, well, that's not conventional to me. Because as the judge found, neither figure 7, which is labelled as conventional, he said in 2272, is not in the prior art, nor was it alleged to be common general knowledge. And
yeah, but that's the relevance of the question that I raised, because the argument against you is that although the judge finds that the statement is factually wrong, he doesn't at least explicitly find that this was a mistake that would be obvious to the skilled reader.
yes, and that's when we deploy the argument, well, if the skilled person's common general knowledge doesn't extend to figure 7, let's make sure we've got it in mind. Make sure I've got it in mind. It's a two-cyclic shift mesh with 2 of the cyclic shifts being for CQI use. So it's core tab 1, and it's at least patent internal page 22. So that's figure 7, and figure 6 only has the two-cyclic shift mesh. But if, as the judge held, and is the case, that in fact isn't part of the skilled person's common general knowledge, when they read conventional, either 6 or 7, they're going to say, well, I don't know that's conventional, that's not part of my basic knowledge.
So your submission is that it's implicit in the findings that the judge did make that the skilled reader would appreciate that this is a mistake.
Yes. And then there's 2 things that could be then said. The first one is, well, maybe the skilled person thinks there's a problem. Do they go and read? Do they, particularly in relation to figure 6, which is given in a paragraph that then starts off talking about Nokia and then moves on to talk about figure 6, would they go and look at the Nokia piece of prior art? Well, Firstly, because of the way Nokia is described in paragraph 11, which is they're only using 6 of the 12 cyclic shifts, whereas figure 6 uses all 12. That doesn't give you a reason to go and look at Nokia because you think it's in Nokia, because it's been described differently. But even if you do go and look at Nokia, even if the school person does go and look at Nokia, it's not there. So either way, it doesn't work for a friend. And you end up with the situation where the school person sees the word conventional, they say it's not conventional to me, and they think it's a mistake. There's a further point on this, because again, this is all driving towards saying, well, the only thing that can give this claim novelty is the actual use. And because the patent accepts this structure as being conventional, it can only be when you use it that it's somehow novel. But of course, the claim has the additional feature of requiring the unusable cyclic shift after the CQI. And that's not in figures 6 or 7. So there's an additional feature, even assuming everything my learned friend says is right, additional feature of the claim. It isn't in those two figures that are said to be conventional. And so this argument that you look at what the patent says, and that drives you to the conclusion that the novelty must rely in the actual use, so I must construe users as meaning actually used. Again, it doesn't get off the ground because it's not the only thing. There's a distinction between figure 6 and 7 and the claim. So a UE that was adapted to spread and transmit in accordance with the claimed code multiplexing structure with the unused cyclic shift would be a different UE, even the one that was adapted to spread and transmit with figure 7, because it would have to have an extra rule in it telling it not to put one in the cyclic shift after the CQI. So even assuming everything else in her favour, it's still a point that doesn't help. So that's the conventional point. Second point on the description that Apple deploys is in relation to paragraphs, I think 63 and 69. And just to give my lord those so you can get your bearings, and then I'll take you back to some of the specifications. So this is 63 is in the start of embodiment 2, and 69 is at the start of embodiment 3. It's columns 13 and 14 of the 549 patents. And what Apple relies upon is the statement that in the kinds of configuration of the base station and the mobile station according to embodiment 1 and differ only in regard to the processing performed by the control channel allocation section. So what I just want to do is to go back through a few paragraphs of the embodiments just to get our bearings, and then we'll come back to this. So if we go back to paragraph 18, which is in column 6, which is the start of embodiment 1. And what that does is that starts off initially with some general disclosure about the components of first the base station and then the mobile phone, and that runs all the way through to paragraph 55. And in 55, then by reference to figure 8, it starts describing how the allocation of the uplink resources is done according to the code multiplexing structure. And in 57, it brings in figure 10, which is the one that the judge referred to. And figure 10 has two cyclic shift mesh for ACNACs single cyclic shift for CQIs and an unusable one. So it is a code multiplexing structure of the invention. And that's the first embodiment code multiplexing structure. The second embodiment is, you can see in figure 12. So if my lords turn over 2 pages and perhaps keep your finger in figure 10, you can see how they differ. So they differ in that the cyclic shift that's used for CQI has moved by 1. So rather than being cyclic shift 3 for CQI and 4 being unusable, in 12 it's 4 that's for CQI and 5 that's unusable. And embodiment 3, which starts in paragraph 68, is figure 14. And in this one, as my learned friend explained yesterday, the cyclic shift interval between resources on the same Walsh code is now moved to 3 rather than 2. Now, the passages that my learned friend likes, where it says that the configuration of the base station and the phones differ only in the allocation of the base station, only makes sense if the mobile has all the code in it to deal with each of the 3 code multiplexing structures. And if I can just explain why that must be the case, it goes back to figure 10. A UE that received a downlink allocation message on CCE 8 in figure 10 would have to be programmed to know that it was going to respond with a CQI in that third cyclic shift resource. That's what that code multiplexing structure requires the UE to do. Whereas in figure 12, which is embodiment 2, the same CCE 8, is an ACNAT resource using Walsh code 1 cyclic shift 3. And so it's a different instruction to the UE based on the same downlink allocation message.
Well, I can understand why you say the mobile must be able to deal with both figure 10 and figure 12. I don't understand why you say it has to be able to deal with figure 14, given that figure 14 is outside the claim.
Well, it doesn't have to deal with it, but a phone that can deal with, if you have a phone that can deal with all 3, then moving between each embodiment, the only difference that happens, the only difference between the setup is in what the base station does, because the phone can deal with all the different code multiplexing structures.
Well, fine, but we're only concerned with what the claim requires. It may be advantageous to be able to handle figure 14 as well. That's not required.
No, but I'm dealing with the point that my learned friend relies upon the wording of paragraph 68, which is in the context of embodiment 3, to say that because the patent says the only difference between the 3 embodiments is what the base station does, that means, again, that the novelty somehow lies in the use. And the judge dealt with this point, and he dealt with it under the issue of clarity in paragraph 435 of the judgment. So you can just turn that up. So my lords can just read that.
I know this isn't what you said, but is there another way of putting the point you're making that, and you say the judge is making, is that what is said in paragraph 69 would be understood to assume that the mobile had the ability to operate in the two embodiments,
Or
and
three.
or three. I mean, it's talking about 1 and 3 there, but it doesn't matter. It has for that sentence, for that paragraph to make sense to the skilled reader would see that what it's talking about is a situation in which the mobile has the capacity to deal with all 3 embodiments, or at least 2 of them. And in that case, the only difference between those embodiments is what the base station chooses to do.
Yes.
But that's why the mobile isn't different, because it has the capacity to do those different things.
That's the point I'm making. My lord has it, and to paraphrase my learned friend, you've obviously put it better than I was managing to do. So that's the. But if it's got the capability to do all those 3, it can move between the different code multiplexing structures when it's told to, and it has the required code to do the right thing according to that code multiplexing structure. But a UE that's only programmed to be able to use, say, embodiment 2 will not be the same UE as one that's only able to do embodiment 3, because they have to do different things in response to receiving the same downlink implicit command.
And something I hadn't understood before, but you said, which answered a question that's been bugging me for a while, is that these commands, the CCE command, if you call it that, implicit signaling, is a command to, if it was number 8, to send a CQI rather than an ACNAC. That's what you said a minute ago.
Well, I think
That's
that's
been answering my question, because I've been puzzling out how this worked. How do the other mobiles know they're not supposed to do something if they're sending ACNACs? How do they know who's doing what?
the reason why I paused was in the standard. The implicit signalling is only used for ACNACs. The CQI resource is transmitted by higher level signalling. So there isn't implicit signalling for which CQIs to use. But the logic of the standard, the math of the standard, means that the UEs aren't able to put ACNACs in the places where they are either for CQI use or unusable. So the math still means that they are adapted to do that. It's just that the way that the signalling for the CQI happens is not by implicit signalling. But going back to the point I was dealing with, my lord has the point, is that these passages that Apple relies upon and likes make sense and will be understood as the judge says when the UE is being programmed to deal with all of them. It's able to move between them, and when it does that, it's the same UE because it's got the programming. But if it hasn't been programmed to deal with, say, embodiment 3, that will be a different UE to one that has been programmed to do it, because it will have different code. And so, again, this isn't a point that drives you to Apple's construction that the word users must mean actually users at all. So the third point that Apple deploys is the nature of the invention. And this is where they say, well, this invention by its nature is really a process. It's a process of managing and multiplexing multiple UEs, coordinating their signals so you get efficient use of the resource, but equally not getting unnecessary interference. And you can't get that by a single UE, so we have to construe the claim as being a process claim. And the judge rejected that in paragraph 248. And we say it's perfectly common and absolutely nothing wrong with claiming, as these patentees have done, a process claim and also a product that's been specifically adapted to operate the process. And there's still a benefit in that, because what one has is a phone that when it comes into a cell where mixed resource blocks are being used in addition with other phones, the phone is able to use those that method. And as we say in our skeleton, a very similar point was taken in the coflexive and Stolt Comex case. If I can just show your lordships that briefly. Always good to wheel out this first ever trial. So that's the authorities bundle tab 6. And if we can pick it up, well actually, no, just to the background, we'll pick it up. It was a patent to a method of laying pipe in the North Sea, so huge, great oil pipe being laid. And the main claim was a method of laying the pipe, and it involved the use of what are called vertical tensioners, which are caterpillar tracked devices that hold the pipe as it goes down to the sea. And if my lords can imagine pipe, big pipe, 2 meters wide on a reel that has to go down to the sea, the pipe has to come off the reel, it has to go vertically into the sea and then lie on the seabed, so it follows a sort of S shape. And the prior art had the tensioners which grab the pipe and hold it horizontal on the deck. And what that meant was that after the pipe went through the tensioners and over the side of the boat, the full weight of the pipe was pulling down as it went through an angle. And that caused all sorts of problems. The pipe was prone to collapse, stretch, and so on. And the invention, which was one of those inventions that seemed obvious in hindsight, but the evidence was that it was a nightmare that no one had thought of before, was to turn the tensioners vertically, such that when the pipe moved from the horizontal to the vertical, it did so not under tension, and then it was able just to fall to the sea in a straight line. So the claims of the patents we can see from paragraph 13, which is on page 295 of the bundle. And claim 1 was a method claim, and we see it's a process of laying from a floating support, a flexible conduit, and then we can skip over the language, and just before the end of that first paragraph, with a substantially vertical axis. And then the claim actually recites the process of passing various accessories, which are things bolted to the pipe through the tensioner. But over the page, there was a corresponding method claim, which was a device for operating a process according to any one of the claims 1 and 2, which had the physical features that allowed the method to take place. And as you can see in the next paragraph, one of the issues of construction, the fourth issue, was should the words a device for operating in claim 3 be construed as meaning a device suitable for operating, or meaning a device when used for operating. So again, the same thing was going on in coflexive. The defendant was trying to construe the claim as meaning, as turning a product claim into a process claim. And the Court of Appeal, and this is Lord Justice August, I think, but it doesn't actually say, dealt with...
It does.
Oh, it does.
It's on the cover sheet.
Dealt with this from paragraphs 23 through to 27. Could my lords just read that to yourselves? So points to highlight. First of all, in 25, the meaning of the claim cannot depend on whether a certain construction would mean the claim was obvious. And that's Apple's final point that we're coming on to, which I'll just note that at this stage. And then the court accepts that the inventive idea was in reality a process, but that doesn't prevent a patentee from claiming a device which is suitable for operating the process, provided that such a device was disclosed in the specification and satisfies the requirements. And of course, we accept that if the consequence of the construction that it's a device, in our case, a phone suitable for spreading and transmitting in accordance with, if that's in the prior art, then that has consequences. In this case, it doesn't. And all the points that Lord Justice Aldous made in paragraph 26 about the patent and its title and its specification referring to a method and a device, all those points can be made in relation to the 549 patents. I shan't drag your lordships through it, but the title refers to an apparatus, and paragraphs 12 and 13 refer to both the method and an apparatus, as does 14. So all those points apply here as well. So clearly, in our case as well, the patentee had in mind both method and device claims. And the same conclusion we say ought to follow. The normal and natural meaning ought to be given to the words.
Presumably the issue in Coflexit was that the device sitting on a ship in a quayside wouldn't infringe on that basis.
Yes.
The only infringement was out in the North Sea, so you couldn't do anything about it sitting in a port.
But equally in this case, on Apple's construction, the point I'm coming on to, an iPhone sitting in a box turned off isn't using the cold multiplexing structure of the claim, and therefore doesn't infringe. And in fact, the logic of their argument is that even if LTE only used mixed resource blocks, and the phone is capable of programmed to deal with mixed resource blocks, sitting in the box and therefore when sold wouldn't be an article that infringed at least section 60 subsection 1. It might be a means essential point available. But we say that it's an unusual construction of a product claim. Whether a particular article infringes a product claim or not depends on something entirely external to that product itself. The normal construction is one can look at the product and make a decision, does this infringe, yes or no? And that doesn't change because something external to the product changes. And we gave an example in our skeleton, is that if one assumes a French equivalent of this patent in exactly the same terms as this patent, if French base stations always have non-zero NCS1 values and do mixed resource blocks, on Apple's case, the patent would be essential and the sales of phones in France would infringe. But the same patents in the UK, on their argument, is suddenly not essential to the same standard, and the sale of the phone doesn't infringe. And we say that just shows you the absurdity of the argument, that a product claim, sensible construction of a product claim, is to be able to work out, by looking at the product, does this fall within the scope of the claim or not having something that changes depending on something else. So then Apple's final reason on construction is the point that they say that the construction adopted by the judge leads to invalidity. And we have several answers to that. The first one is the point that was made clear in Coflexit, which is merely because there's an invalidity consequence isn't a reason to read the words one way or the other. Now there's a nuance to that, which is where the piece of prior art was acknowledged by the patent. I'll address that in a moment. But
well, particularly you've got to distinguish also between novelty and obviousness, because the Virgin principle is really about novelty, not obviousness. Whereas, of course, the argument in Coflexit, as we saw, is about obviousness.
But here, as the judge has held, his construction doesn't lead to invalidity in fact. And even though patent refers to Nokia prior art, there's nothing in the patent that suggests that patent is invalid over Nokia. This is, I think, my Lord Justice Birss, I think it was, said yesterday. When the patent refers in paragraph 11 to the Nokia prior art, it refers to Nokia only using half the cyclic shifts, not all of them. So there's no reason to the skilled person reading the patent to say, well, hang on, I've got to read this in a different way because if there's a problem with Nokia. And there's nothing, and that was part of the judge's reasoning in 252 of his judgment. The potential invalidity just isn't apparent at all from the patent, and therefore isn't a reason to adjust the construction. Now, my learned friend then ended up yesterday by saying, well, because Nokia is referred to in the patent, you have to construe it narrowly. But she didn't condescend to any detail of what that meant. As my Lord Justice Arnold said, normally one's looking at a particular word and saying, well, if I construe it to mean one thing, then that would read onto the prior art, so I must read it the other way because they've acknowledged it. But here, Apple just say, well, you have to construe it narrowly. It doesn't explain what that means because every patent acknowledges a piece of prior art, and unless one has an issue, unless the skilled reader reading the patent can perceive a particular issue of construction from the acknowledgement of the prior art, there's no reason for them to take that into account at all. And merely saying construe it narrowly doesn't really take one anywhere, and certainly doesn't take you to the conclusion that she wants to get to, which is that this claim has to be construed as meaning it's only infringed by the actual use. I think her only reasons in her written skeleton, my learned friend says that the validity would be apparent, are the conventional point and the power 63 and 68 points that I've already dealt with. So I think unless my lords have any more questions on the construction point, I'll move on to the infringement point and the adapted to point. So, as with this case, we have to work out the basis that we're dealing with this point on. So we're now dealing with this point on the assumption that the judge was right on construction and that the claim doesn't require actual use, it just requires the phone to be adapted. And adapted to in the sense that the judge has explained in 244 that the phone has been programmed in a way that makes it put the ACNACs and the CQIs in the places where they're meant to go and not put them in the places where they're not meant to go. And Apple's case, as my laws will have now, is that its phones are not adapted because they need to be reconfigured by the base station before they can do that. And we end up in what my submission ends up as being a word game of semantics about what reconfigured means. Now, apologies if my lords have this, but there's a lot of detail in this case, so I'll just go over the facts in relation to the infringement case. So there's 272 of the judgments. So as in all mobile networks, one of the things that the base station does is have a channel called a broadcast channel, which broadcasts system information to all the UEs in the cell to give them important information about how to work with its network. And one of the parameters that's broadcast in an LTE cell is this parameter NCS1. And it's always broadcast by base station. And if the parameter is a non-zero number, then there will be mixed resource blocks. And if it's 0, there won't be. And now there are other parameters that are relevant to the resource blocks that are used in the code multiplexing blocks. But the key point is NCS1 is always transmitted. And the phones, LTE compliant phones, have to be able to process the value of NCS1 that's transmitted. And they are all able to do that. And depending on the particular value that's transmitted, they will do different things. But the logic is there in the phones, and it's there in Apple's phones, to allow them to implement mixed resource blocks if a non-zero number is transmitted. And we saw a moment ago from the judgment the two situations, the roaming and the compliance test, why even in for UK phones it's important. Now it's not in dispute that Apple phones can do this, and what may be helpful is just to look at paragraph 275 of the judgment, where the judge shows the images of some of the LTE code multiplexing structures. And these are all code multiplexing structures that can be generated in LTE, and they vary on two parameters. The first one is delta shift push, and we see the first row of 2, delta shift push is 2, and then it's 3, and then 1. And what that is the cyclic shift interval between resources on the same Walsh code. So if we look at the top right-hand one, where delta shift push is 2, we see that for orthogonal code 0, you use cyclic shift 0, and then the next one is cyclic shift 2, and so on. And in the next row, in the middle row of the two tables, delta shift push 3, we see that there's a 3 cyclic shift interval gap, and delta shift push equals 1, we see that there's no gap, because they go straight from one to the next one. And then the other difference is the NCS 1 parameter. And in these examples, they're all non-zero numbers. If there's NCS 1 parameter is a 0, then there wouldn't be any CQIs or any unusable shifts in the block. But when it's a non-zero number, what actually NCS 1 does is it dictates how many cyclic shifts are usable for ACNACs, the remainder being CQIs or unusable. So we see in top right, NCS 1 is 4, and the first 4 cyclic shifts are used for ACNACs, and in the one below it, so middle right, it's 6, and we've got 6 rows. Now, the judge deals with all this, and in these 275 and 276, one point I just need to, which again I don't think has been challenged by my learned friend, is the one the judge makes in 277 and 278, that each of these structures in those diagrams are all separate code multiplexing structures. And in 277 in the middle, the judge says each of them is a code multiplexing structure, however, and an LTE compliant mobile will have to be able to work with all of them. Apple made an argument that all 6 examples ought to be aggregated in some way to work out what the code multiplexing structure was, with the result that the code multiplexing structure allows all possible resources to be used for ACNAC. In that case, Apple said there's no infringement because there's no longer a 2 cyclic shift mesh. And the judge rejected that on the basis of his definition of a code multiplexing structure. And that's the code multiplexing structure is the resources that are available to be used at any one time. So when the base station is broadcasting, for example, delta shift push 2 and NCS 1 of 4, the resources that are available are in the ones in the top right-hand corner. all of those ones are available, and they are the code multiplexing structure. If different parameters are transmitted, then the code multiplexing structure will change, and different resources will be available. But what you can't do is notionally sum them all up and say that all of them are available, because you can't have all of them available at the same time. And again, the reason why I'm just stressing that point is because, again, it comes back in on Nokia, because they try to run a squeeze in relation to doing this in relation to Nokia. Now, I think with that, we probably need to go and look at IPCOM and Vodafone. Hopefully we can do this a bit quicker, because my lord will be familiar with the relevant paragraphs. So that's Authorities Bundle tab 4. And what we say, just stepping back, what Apple trying to do with IPCOM and Vodafone is draw a factual analogy with the facts of the case, and in particular have latched onto the use of configuration, which actually, when one looks at the paragraphs of the judgment, comes from the summary of the evidence as to what was being done, and they tried to elevate that to the test. And as I'll show you, your lordships, and just to give you a preview, where we say you end up is the relevant test from IPCOM and Vodafone is there infringing circuitry in the device at all times, even if it's not being used? That's the relevant test, and the Apple phones satisfy that. So if my lords can turn to paragraph 106. So we start with the acceptance that set up to send meant either there's appropriate programming in the base station, or that it's adapted or configured for that purpose. And then in 107, we get Counsel for Vodafone's summary of the evidence of what had to be done. And as was discussed with my learned friend, that involved the operator, the engineer, logging into the network management software, mapping the location of where the event, the emergency situation was happening, selects the access classes to be barred, and then the script automates the configuration changes that are required in order to implement the MT-pass response. And then commands are sent in 5 to each relevant OSS. Each relevant OHS sends commands causing configuration changes in each of the relevant base stations, and so on. Now, of course, in this case, the article that was alleged to infringe was the base station. And what was going on was that human interference was having to happen to change a base station that couldn't do the thing that the claim required and wasn't programmed to do it into one that could do it. And my learned friend this morning latched onto the human interference point in relation to this case and said, well, someone has to decide to implement mixed resource blocks to in this case. But of course, no one is changing the article alleged to infringe in this case, which is the phone, which is absolutely identical piece of equipment that has the same code and can do the same things in it. And there's the faction. This is where the faction analogy breaks down, because in Vodafone, what was happening was the base station was alleged to infringe, and it was the base station that was having its, whether one calls it programming or configuration, changed. Here, nobody's doing anything to the phone. Now, then in 110, my Lord Justice Arnold refers to my Lord Justice Birss's decision in Phillips and intended, and the general understanding and construction of means plus function type claims, which isn't in dispute. And then in 111, there's another passage from the judgment in Philips and Nintendo, where at the end of that passage, this was the case about the Wii balance board and the software disk. To be within the claim, it seems to me that the relevant disks, such as the disk carrying the island cycling software, at least has to be inserted into the Wii unit, and the balance board has to be connected. In that state, whether the unit is switched on or switched off, it seems to me that the claim is satisfied on the assumption I've made. So once the disk has been put into the machine and the balance board connected, there was a device that had all the programming in it to do the infringing act in that case, even though it wasn't powered up and the software wasn't loaded into memory. And that was the acceptance that Counsel for IPCOM made in paragraph 112, a claim for means suitable for carrying out the function to satisfy it if the software is present in the apparatus, even though the software hasn't yet been loaded into memory because the apparatus hasn't been switched on. There's then a recording of the fact that the evidence in Vodafone required changes of programming of the software and changes of configuration, however one wants to put it, to change the base station from ones that weren't set up for send to ones that were set up for send. And then over to paragraph 116. This is where my Lord Justice Arnold deals with the dispute about whether the judge's judgments, which recorded reprogramming, or the annex, which talked about changing the settings, was the right description. And in 117, my Lord held that changing the settings was more accurate, but you didn't accept the argument that changing the settings of the base station is equivalent to the scenario considered in Philips and Nintendo. All that had to be done in that case was for the apparatus to be switched on, at which point the software would be loaded into memory and would start running when it would satisfy the requirements. In the present case, the settings of the base station have to be changed by the operator to make them operate in a different way. It was true whether it was done manually or not. And then, my Lord, I do not accept Counsel for IPCOM's submission that this is analogous to a radio that has a switch to change from mono, non-infringing, to stereo, infringing, because in that scenario there will be infringing circuitry present at all times, even if it was not in operation in any particular time. And our submission is, if one's looking for the ratio of this case, about what's required for something to be to meet the requirements of an adapted for claim, that, we say, is the touchstone, rather than playing games with whether it's adapted, whether it's been reprogrammed or reconfigured or had the settings changed. Does the infringing circuitry exist at all times, even if it's not in operation?
Does that mean that really you're just saying reprogramming?
Well,
I mean, is anything, if you're, on your case, if you're not reprogramming, it's adapted. But the reconfiguration or changing the settings doesn't add anything.
No, it has to be able to do it. And so there's two situations where the article may not be doing the thing that it's been programmed to do. The first and simple one is because the power hasn't been turned on. And that was the example that my Lord Justice Birss gave in Philips and Nintendo. So you turn it on, plug it in, and it works. It's adapted to do it. The second one is the example that's given in paragraph 117, the radio, which is flicking the switch. So you have a radio that can do non-infringing mono or infringing stereo, and all you have to do is flick the switch, and it does the stereo mode. And that, because it's got the circuitry to do that, we say is satisfies an adapted for, suitable for test. And similarly, a device that's got the functionality, but it needs to be activated in a way that isn't a manual switch. For example, having a signal sent to it to to say, load this bit of software into your memory and do it, is equally adapted for. And that's precisely this case. The functionality is all there in the Apple phones, and effectively it's the signal of NCS1 being set to 0 to 1 or a non-zero number is effectively a soft switch saying activate this programming that you've got.
The key point in IPCOM is that without the intervention of the operator, the base stations could not operate in the Annex C mode, which was the infringing mode.
Yes, and the phones in this case
Could not.
And the phones in this case can. And yes, they have to be told to operate in accordance with that mode that they've been programmed to do, but that's a switch.
Yep.
It's a more modern way of switching between a stereo and a mono mode.
Is that quite consistent with the case you've just been putting? I'm not quite clear. On that thesis, the human intervention is key, whereas the circuitry was always there. So I'm not quite sure how you fit those two things together.
Well, the circuitry is always there in the phone, and it has to be informed to operate in a particular aspect of the circuitry in the same way that someone has to plug the Wii in the mains and turn it on to make it do the particular game that we were concerned with in Philips and Nintendo. The difference between IPCOM, where the article alleged to infringe the base station, as my Lord Justice Arnold says, could not do the infringing method and therefore was not set up to send until someone changed its settings or its programming or however one wants to characterize it. It was that article that had to be changed. Here, phones don't have to be changed at all. They are the same phones, they've already got the programming in there, and they can do it as soon as the switch is flicked and they're told, use X resource blocks.
I'm probably not sufficiently on top of the facts. Was there a reprogramming involved in IPCOM?
Well, this was the dispute.
Well, that was essentially a semantic point. I mean, the judge used two different expressions, and what I held was that the expression changing the settings was a more accurate language, but it's not the real point of the case.
No. I mean, my Lord, it all depends on what one means by programming. And obviously,
Well, quite.
what one doesn't have to do is throw it all away and write a whole new set of code from the beginning, but you have to change something within the code that's in there to allow it to do something that it previously couldn't do. And until you do that, it simply wasn't suitable to do the infringing process that the claim required. In contrast to LTE phones and the Apple phones, which they're ready to go. And I mean, my Lord Justice Birss came up with an example, and of course it won't surprise you to. We'd been thinking up examples before as well. The one that I came up with two, so I'll give those a whirl and see how. It may not matter, but my Lords will be aware that all modern phones, the 4G phones, can also do 3G and 2G, because one doesn't know where in a network you're going to come to, and many of the networks keep the 3G networks going for old phones and also to offload busy cells when there's too many phones wanting to get too much data. So all modern phones have circuitry in them to do 4G, 3G, and probably 2G as well. And the way a mobile that's on 4G cell, sitting there happily trying to download some data, the cell determines that it's too busy and you're the poor person that's going to get kicked off to 3G to free up some capacity, and it sends the UE a signal saying, please retune to a 3G cell, go and search and find it. And the phone has got all the circuitry in it to do WCDMA 3G, and it will do that. But it has to have a signal sent to it saying, please now go away, go to a UMTS cell. And the logic of Apple's arguments is that's a reprogramming of your phone, and prior to being told to go and camp on the 3G cell and leave the 4G cell, that phone wasn't adapted to operate in accordance with UMTS. And we say that's just, it just shows the nonsense of the argument that all it's being done is being given a command to go and do something. The other one, slightly more low level, was televisions are able to tune into multiple different channels. One focuses on the 5 terrestrial channels at least. They're able to do that. They obviously have to retune their antenna, moving from BBC 1 to BBC 2. And the way, as an operator, you make it tune its antenna is you press the button on the remote control, it sends a signal to the television, it retunes its antenna and does that. Now, that isn't reconfiguring the television, reprogramming the television. The television isn't not adapted to tune into BBC 2 just because it has to receive a command external to it, telling it to change something within it and retune to the channel. It's perfectly adapted to do it. And the fact that it needs a switch flicked, which could be a...
All right, but the problem with all of these analogies is the facts are always different. And what I find surprising is that nobody's actually addressed us on what the underlying principle is. Because what we're really talking about here is there's different circumstances in which product claims are infringed as distinct from method claims. Because in all of these scenarios, a method claim will generally be in the patent as well, which may or may not be infringed depending on the circumstances. And the whole point is, supposing that for whatever reason the method claim isn't infringed, whether it's because nobody's interested in doing it in the UK, which is this case, or because it's emergency only and never in fact done for real, which was the scenario in IPCOM. And then the question is your product claim infringed? And in answering that question, it's relevant to ask oneself, well, should it be infringed? And the answer in IPCOM was no, it shouldn't, because you had to change the physical device when the emergency scenario cropped up to make it operate in accordance with the infringing method. And so in ordinary operation, it was a non-infringing device from the common sense point of view. And if it was ever used in the infringing method in an emergency, well, that would be an infringement of the method claim, and we deal with that as and when. By contrast, you say, in this case, there's no change to the mobile required whatsoever, and therefore it should be an infringing device.
Yes, well,
that's the real point, isn't it?
That's the point. And so my lord says, what's the principle? And that's why I tried, I didn't make it clear enough, but if one's looking for what's the test, no matter asking about is it reprogrammed or is it reconfigured, the test is the one at the bottom of 117. Is there infringing circuitry present at all times, even if it's not in any operation at any particular time? If that's satisfied for a device and for this claim as well, then we say that there's infringements, and that was the logic and the reasoning in IPCOM, and it leads to the conclusion of no infringement in IPCOM because that circuitry wasn't there because it had to be changed, whereas it leads to a conclusion of infringement in this case because the logic and the programming is there at all times, and all it has to be done is activated by the equivalent of a flick of a switch. So unless I can assist your lordship further on that point, I'll move on to Nokia. So again, getting our bearings, this point now is expressly conditional on the judge being right on the previous two points, both in relation to construction and in relation to adapted to infringement. And it only hits EP 549, so it's not a complete escape for Apple. If they've lost on the previous 2 points, they need to win as a practical matter both on this point and on the 810. So can we look at Nokia itself, which is Supplemental Bundle tab 5. And what I want to do is go through the teaching of Nokia and perhaps from time to time look at the judge's findings in relation to it before coming back to the arguments. And again, at the outset, before we set off into Nokia, where we're going to end up, it's very important to understand what the code multiplexing structure of the Nokia phone is, and what the Nokia system is, and to give my lords the answer, and I'll make this good, it's the entire available code space. The UE is able to fill in and transmit in all parts, all 4 Walsh codes and all 12 cyclic shifts of the Zadov-Chu sequence. And that was a point my learned friend skirted around yesterday. But it's a key difference between the Nokia phone, the Nokia system, and the phones of the claim. Because the way my learned friend put her case was that the Nokia phone is no different from the phone of the claim, but it is in that key respect. So, starting off with the introduction, it's dealing with code resource allocation for downlink ACNAC signals transmitted in the uplink by the push. So this is, again, it's what the phone is sending back to the base station in response to downlink data that's been sent to the phone. These resources are utilised by the EU, which only have ACNAC signals to be transmitted, but neither uplink data nor the periodic CQI. So it's only dealing with the ACNACs, and the reference to neither uplink data is the point my Lord Justice Birss made, or when the penny dropped earlier this morning, that if the UE has been allocated uplink data, it sends its ACNACs on the data channel, not on the push. Then it refers to the format, the agreement that had been reached in the meeting 48 bis in Malta, that the ACNAC is transmitted by means of a modulated Kazakh sequence, and ACNAC signals of UEs can be orthogonally multiplexed inside pilot data blocks using cyclic shifts of the same base sequence. The length of the sequence is 12 symbols, and coherent transmission with 3 reference symbols, RS blocks, 4 data blocks, ACNAC is applied. Just unpacking that a bit, that's a reference back to the fact that there were going to be 3 reference symbols and 4 data symbols in each resource block. And then the third bullet, block level spreading with spreading factor 3/4 is applied for the reference symbol data blocks. And again, that's the consequence of the fact that there are 3 reference symbols and 4 data symbols. So the length of the code to spread the reference symbols was going to be 3 long, and the length of the code for the data ones was going to be 4 because there's 4 symbols that are being spread over. Different ACNAC UEs are multiplexed by means of code division multiplexing. There are in total 12 times 3, 36 resources available for reference symbols, and that's a consequence of the fact that there are the 12 cyclic shifts, and then each of those cyclic shifts can be multiplied by one of the 3 different orthogonal sequences, so you get 36. And then for data signals, it's 12 times 4 because you've got additional orthogonal codes. And they say it doesn't make sense to allocate these resources explicitly since the resource size is always fixed. Instead of that, implicit resource allocation is for downlink ACNAC signals transmitted and the uplink is applied. It was decided in the last round 1 meeting 49 held in Kobe, and then it sets out verbatim the Kobe agreement. And then they say they're going to deal with the allocation and signalling of the resources, and they'll present a signalling scheme that can be used to map the implicit control channel indexes into physical code resources of the push. And then briefly in section 2, they talk about certain principles should be applied, and then there's a reference 7, which was an issue at trial that thankfully my lords don't need to worry about. And they say, we know that parallel code channels transmitted on a push interfere with each other in a practical system. Orthogonality between different cyclic shifts is limited by delay spread of the radio channel, and that was the point I was explaining to my lords this morning, that a delayed sequence with no cyclic shift looks identical to a non-delayed sequence with a cyclic shift of 1. And then the second bullet is orthogonality between different cyclic shifts of the block code is limited by Doppler. And so they say it can be shown that adjacent cyclic shifts in both frequency and time domain have the worst orthogonality properties due to inter-cell orthogonality issues. Only part of the resources can be used in practice. Now, there was a big dispute at trial about whether the skilled person would understand that statement to mean that Nokia was saying that adjacencies were forbidden or not. The judge, it was Apple's case, that they were forbidden, and the judge rejected that and held that it wasn't a forbidding. And then if we go over the page to section 3, it talks about the factors that affect, or the configurations of the implicit ACNAP resources and the parameters that affect it, which I think we can move over and go over to section 4, which I think is where my friend pretty much started. And the static input parameters are listed first, and the first one that's, hopefully my lords have crossed out the first num F shift and written a T over it, because as my learned friend explained, that was common ground, that was the typo. That's the number of cyclic shifts of the block spreading code, and that's the spreading factor of the orthogonal code. Is it 3 for reference or 4 for data? And then numF is the length of the Kazakh code, and it's 12. And then the semi-static parameters, and it may be helpful at this stage to have judgment open at the same time, just because the judge gives a little bit more explanation as to these points, and that's judgment power 362. I meant 367. So the first one is res first, and my learned friend explained this. It's not the most straightforward thing to understand. Do my lord have that? Shall I just give it one more go? So res first, it says the resource number of the first implicit resource. The applied resource numbering is presented in figure 2. So if we turn over the page to figure 2, that has the numbering of the implicit resources that are available. So you see we've got 4 orthogonal codes, 12 cyclic shifts, so you've got your 48 square grid in figure 2.
Sorry, I'm lost. Which document are you looking at?
I'm Nokia, my lord.
Nokia.
Sorry, I
judgment.
forget my lord's doing it.
All right. No, I just thought you were in the judgment. That's all.
Well, I was in both, which is my fault.
Okay.
So, just going back then to page 88 of the bundle, which is section 4, for my lord. Res first is the resource number of the first implicit resource. The applied resource numbering is presented in figure 2. And you see there, each square is numbered from 0 to 47 in that slightly odd way that we discussed yesterday. And the answer as to the significance of the blue colours is, as far as we're aware, no expert mentioned it. There was no discussion at trial, so we can't help you on that one. And as far as the fact that the numbers shift down in each column, again, same answer, but we suspect it's something to do with making the maths of the equations below figure 2 work, but again, no evidence as to that. What res first is where in the overall numbering scheme in figure 2 a particular scheme starts. So if we look at figure 3 at the bottom of page 89, which has a res first of 0, you see the first one goes in cyclic shift, row 1, row 0, column 0, which is the blue one top left, and that is implicit resource 0 in figure 2. Similarly, for the middle one in figure 3, which is res first 30, you see that the 0 is in column 2, row 8, and if you look up column 2, row 8 in figure 2, that's 30. So it's a starting position that you start numbering from, albeit that you always start from 0, which is the slight complication. So that's res first, and the judge explains that at 367. And if we go back a page in Nokia, the next parameter is shift diff, and that is the cyclic shift difference between two implicit resources. So if we go back to the next page in figure 3, although it's not marked on these figures what the shift diff is, if we look at the middle one, you can see that shift diff there is 2, because you go from 0, then you drop down two rows to get to the next one, which is 1, and so on and so forth. There's a gap of 2 between them all. And in the right-hand one in figure 3, shift diff is 4, because you're moving from the 0 resource in column 1, row 2, to the first one in column 1, row 6. And it's the equivalent of delta shift push in LTE. It does the same thing. And going back to page 88, the third semi-static parameter is implicit res, which is the resource number for ACNAC tied to the downlink control channel index and signaled implicitly. And that's what the UE looks at from the downlink control channel index, and that's one of the inputs into the algorithm on page 89, which works out where the resource ultimately is. And that, looking forward to if one's looking for equivalence to the pattern, that's the equivalent of the CCE number. But of course it's different because it's the index of the control channel.
The description in figure 1 of the parameters as being constant, signalled and output makes a bit more sense than static and semi-static, or at least I find it easier to understand.
Yes, but what one sees is you have a system where you know what the num-f shift and num-t shift are, because that's the spreading factor of the Walsh code and the length of the Kazakh sequence. You plug in the res first, which is the downlink signalling, the shift diff, and where you start from, and the algorithm spits out shift T and shift F. And of course, in any cell, the only thing that's really going to change is implicit resource, because from instant to instant, of course, the base station could reconfigure the shift diff, but as one goes along, and the maths, I had the pleasure of trying to turn that into an Excel spreadsheet for my own edification. And when you work it through, you put in the different implicit resources, and it spits them out, and it does. It was common ground by the experts that it does in fact work.
And if, in effect, the code multiplexing structure defined by this is defined by those 4 parameters, the 2 constants, the 2 signal parameters, and not the imp res, the top 2. If you have the 2 constants and res first and shift diff, then you have a code multiplexing structure. You don't have one in accordance with your claim, you say, but you do have one.
Well, what the code multiplexing structure of Nokia is all the resources, because as the UE is able to use all the resources, as you can see from these figures, it spits them all out. There's no way of preventing it from using any one. So actually the code multiplexing structure is dictated by num-f shift and num-t shift. What res first, shift diff, and implicit res do is dictate the order in which those resources are allocated to a mobile as you go along.
Okay.
So they
Is that
don't.
part of your code multiplexing structure?
Well, the code multiplexing structure of Nokia, code multiplexing structure being the available resources that the UE can use, is the whole space. And that was the judge's finding in our come on to show my lord that.
Okay.
It's different. Now, and so just to make that point good, each resource in the tables in Figure 3 has a number. And we say what that means is that the UEs, the UE program to do what Nokia teaches, would be able to use all those as resources. And so the judge made a conclusion about this because it was obviously important. So if we go to the judgment and go to paragraph 372, he says every cell in the tables in Figure 3 has a code allocated to it, so in principle could be used. Apple says this would not be done in practice because it would lead to adjacencies and unacceptable interference. And as I've mentioned, he rejected the adjacencies points. He then came back to this in the obviousness case 401 and 402, where, again, just to give my lord your bearings, he's here dealing with the issue about 2 codes for data and 2 cyclic shift gap in the section that starts at 397. And at 400, he says, I move on to consider the 2 cyclic shift gap issue. Nokia says that there should be a 2 cyclic shift gap, does not say that there should be a 2 cyclic shift gap, and indeed Table B does not show any gaps at all. Apple's case is the 2 cyclic shift gap would emerge if only 18 EUs were scheduled. Given my interpretation of the code multiplexing structure, the code multiplexing structure of Nokia are the whole grid of numbers from 1 to 36 or 1 to 48, as the case may be, and not just that part of the numbers in use at any one moment, depending on how many EUs are scheduled. For example, it would not be the case that the code multiplexing structure of Table B would be just the single resource first equal 30 if there are only 1 UE scheduled. Nor is the code multiplexing structure of Table B the first 18 numbers which are there when 18 UEs are scheduled. So that's an important finding, we say, that the judge is drawing the distinction, consistent with his construction, which my learned friend didn't challenge, that there's a difference between the available resources, which in Nokia is all of them, and those that are being used at any particular time. And he goes on to say in 402, there's hindsight in postulating that the skilled person would look at Table B and mentally shade in just 18. Nokia clearly provides an algorithm which can allocate all the resources, and there's no reason to think that they would necessarily be allocated the numerical sequence of Table B. This is connected to a point on 810 that I'll consider below. We'll come back to it in a minute. So we say, well, that this point is central to the appeal in relation to Nokia.
Just remind me, Table B is...
Oh, yes, sorry, my lord. This is the fact that the parties at trial had
back at
labelled...
page 89, the middle one at the bottom, or something different.
Yeah, it's paragraph 369, the middle on the bottom. It's Figure 3 from the patent, but because they're not labelled... Nokia.
Yes.
They're not labelled in Nokia at trial. One of the witnesses labelled them, and we all started referring to them as such. Now,
as I understand it, A, B, and C are 3 different CMSs.
Well, they are. The difference is between them is that.
Well, I know what the differences between them are, but why are they not 3 different CMSs? Are they just one CMS?
No, well, certainly the one with numpty shift of 4 is a different code multiplexing structure because that allows 4 codes to be used.
Okay.
And that would be understood to be for the data signals. The 2 with numpty shift of 3, the judge found, would be for the reference symbols because there's only 3 Walsh codes being used. It was another big debate we had at trial that the judge resolved in our favour. And those are, it's the same codes can be allocated. The difference between them is the order in which they are allocated. But ultimately, the code multiplexing structure is all of them in both cases. And there's a, and my lord sees the difference between the 2 cyclic shift mesh of the claim, where the resources outside of the mesh are simply not available to be used by the UE or allocated to the UE. They just can't be used. Whereas in Nokia, all of them can be used. wasn't in dispute at trial, and I shan't take your lordships to the evidence where it was dealt with, that Nokia did allow all the resources to be allocated. As we said, the judge found it. So that's the
Sorry, just help me to understand that. Allows all the resources to be allocated, but this is about reducing interference.
Yes.
So the idea is you do get spaces between signals.
Well, this is where on appeal this can get. What happens is that one of the disputes I mentioned a moment ago was whether that passage in Nokia that says, let me get the wording right rather than remembering it from a year and a half ago. It can be shown that adjacent cycling shifts in both frequency have the worst orthogonality properties due to intra-cell orthogonality issues. Only part of the code resource can be used in practice. There was a debate between the experts about whether that meant Nokia telling you don't have any adjacents, or whether it was just saying, well, avoid them if you can, and there's a balance to be had between capacity of the cell and interference, and where you draw the line. Do you tolerate the occasional adjacency? Do you have none? And the judge held that Nokia wouldn't be understood as forbidding adjacencies.
So is the point that on this theory, or given the judge's finding, Nokia is designed to reduce adjacencies or reduce potential gaps, but potentially will tolerate them?
Will tolerate them because you may find maybe the decision in some circumstance, maybe the conditions are good and I will tolerate them and will tolerate some errors. It's a sort of design. The Nokia system allows that trade-off to be done in different places. And just for my Lord's note, it's 403 of the judgment where the judge rejected the premise that Nokia teaches there must never be adjacencies. The last part of Nokia teaching, which is I can probably do in the next 5 minutes or so, and then that might be a convenient moment, is the section on page 90 of the bundle. So it's over the page from where we were looking at figure 3 is. And this is where the passage that starts just above the hole punch. It's beneficial in some cases to allocate implicit ACNAC resources from the limited code space. This is the situation where periodic CQI and ACNACs from different UEs are transmitted in the same resource unit. Limited code space requires 2 additional semi-static parameters. Allowed T-shift, bit field containing allowed cyclic shifts at the block level, and allowed F-shift, bit field containing allowed cyclic shifts at the frequency domain code. And what this allowed, part of Nokia allowed to happen, was the base station to signal to the phones that for implicit ACNAC resources, so these are ACNACs that are being sent in response to a data packet on the downlink, and taking the location of that resource from the index of the control channel used to signal it, you could limit the area of the code space down. But if you did that, what would be used in the other parts of the code space would be periodic CQI and periodic ACNAC from different UEs. Now, CQI was generally periodic. The mobiles would be configured to send CQIs on a certain timescale. Periodic ACNACs are used in some situations, and it's particularly when VoIP, voice over IP, is being used, where you know that the UE is going to be consistently transmitting data, and therefore it makes sense to give it an ACNAC resource that it can keep repeatedly using, because you know it's going to need to keep sending acknowledgements, and that makes more sense than constantly implicitly doing it. And what Apple seek to do is to say that the allowed T shift and the allowed F shift prevented either the cyclic shift or the Walsh code from being used entirely. But what the disclosure of Nokia is that they're there to prevent them from being used for implicit ACNACs and allowing them to be used for periodic CQI in the case of allowed F shift or periodic ACNAC in the case of both.
Are you moving on from this document?
Well, I was going to come to the judgment on Nokia now, so it's probably a
Yes.
relatively separate topic.
Yes.
My lord, I'm making good progress.
Yes.
I'm about over 2/3 of the way through my note, probably 3/4.
I'm not holding anybody to anything. I'm vaguely hopeful we will finish by lunchtime. But,
I suspect that may be shared by other people in the room.
good. Well, 10:30 in the morning.